Good morning, everyone. I, Dr. Rahul, welcomes you all for one-day workshop on intellectual property rights, organized by IIC and Amity Institute of Biotechnology in collaboration with Intellectual Property Office, New Delhi, Government of India. Moving forward, I welcome our keynote speaker, Mr. Ashish Prabhat, sir, Honorable Vice Chancellor, sir, respected Director, sir, respected registrars, sir, and our esteemed faculty members and my dear students. Before I start, I would like to request Dr. Dhananjay Kumar Pandey, sir, President IISc AUJ, for a welcome speech. Over to you, Dhananjay, sir.
Thank you, sir. With the blessings of our Honorable Founder President, Dr. Ashok K. Chauhan, sir, our Chancellor, Dr. Atul Chauhan, sir, and guidance from our Honorable Vice Chancellor, sir, respected Director, sir, and respected Registrar, sir, it's my pleasure to welcome all dignitaries and participants in this workshop on intellectual property rights, jointly organized by Amity Institute of Biotechnology and Institutional Innovation Cell, Amity University, Jharkhand, in collaboration with Intellectual Property Office, Delhi, Ministry of Commerce and Industry, Government of India. At Amity University, Jharkhand, with the help of R&D Cell and IIC, we are trying to create an atmosphere where all faculty members and students will be motivated for research and innovations. Once we develop or create any tangible output from our intellect, it's called intellectual property. And similar to physical property protection, we also need to protect our intellectual property. I hope this session will help us to understand different aspects of intellectual property and how we can protect them. With these words, I would welcome again you all and request Dr. Rahul sir for further progression of event. Over to Dr. Rahul sir. Sir, please.
Thank you so much, sir, for the welcome speech. Now, our respected registrar, sir, and director, sir, has conveyed their best wishes to the organizing committee, along with the keynote speaker, Mr. Ashish Prabhat, sir, for this session. So now I welcome our keynote speaker, Mr. Ashish Prabhat, sir. But before that, I would like to read his brief profile so that our audience will get aware of him. Ashish Prabhat, sir, is examiner of patents and design, Group A officer, and NIPAM officer in Indian Patent Office, New Delhi, Ministry of Commerce and Industry, Government of India. Mr. Prabhat deals national and international patent application related to biotechnology, agricultural science, biochemistry, and food science. He has completed his graduation from Dr. Rajendra Prasad Central University, Pusa, Bihar in biotechnology, and post-graduation in biomedical science from University of Delhi, followed by PGD in intellectual property right from IGNOU and LLB from Meerut University. This is a brief profile of our keynote speaker, Mr. Prabhat, Ashish Prabhat, sir. Now I request our keynote speaker to share his screen and start the session. Over to you, sir.
Thank you, sir. Thank you, Dr. Rahul, for giving the brief intro of mine. And respected Vice Chancellor, sir, Director, sir, Registrar, sir, and the moderator, Dr. Rahul, event convener, Dr. Amit Kumar Datta, and President IIC, Dr. Dhananjay Pandey. It is my great opportunity to deliver a lecture on the intellectual property right under the NIPAM program. And this NIPAM program is running by our ministry under the celebration of Azadi Ka Amrit Mahotsav, and it is the great initiative of our ministry and our visionary Prime Minister, Sri Narendra Modi. He has given a target of 10 lakh students from class 8 to PhD for the awareness related to IPR and different IPs like design, trademark, patent, copyright, etc. So it is a chain of intellectual property awareness program, and thank you, Dr. Dhananjay Kumar Pandey, for giving me and for inviting me for this lecture in your university. So I will start in a few minutes. Share screen. So slide is visible, Dr. Rahul.
Yes, sir, it is visible.
Okay, thank you. So first of all, we should know that how many types of IP is there in India and in other countries also. So we give the intellectual property protection under the patents, designs, trademarks, geographical indication, copyrights, and semiconductor. So this is a beautiful example of IP in a single object. You can see you are seeing a Apple laptop in which the LED display comes under the patent, and the body of designs will be protected under the design, and the Apple sign, which is the trademark of that Apple company, and the general user manual is given with all the machines and devices for the how you can use this machine. So user manual will comes under the copyright protection, and the layout of the integrated circuit will come under the SICL design. So we should know that if you have any IP, if you have done any invention or the research, then you should know where I can go for its registration or for the grant. So in a single device, many times a scientist made design a machine which has a property like an agriculture machine by which you can harvest the crop or by which you can irrigate the crops. So you can get two patents in a single invention. First for the patent, and second you may go for the design also. So these are the rationale of the patenting system. What are the pros of patenting system? You will get incentive to do innovation and investment in R&D activities in any field, dissemination of technology, commercialization of invention. I will discuss in detail how you can transfer your technology to the manufacturer or to the industries, or how you can get the incentive from the different funding agency for after getting your patent, and how you can promote technology transfer.
Sorry to interrupt you, sir. Can you please full screen the slide?
Slide is full screen. Your slide is full screen,
but it is not changing. That's why.
You are seeing the same slide.
Exactly.
Sir, we are in the title slide only.
Exactly.
So yeah, now it's moving.
Now it's moving.
But I think that you can press F5 so that it will come full screen.
Slide is changing now. No.
Sir, in your slide in the above, you can see home, insert, design, animation, and slideshow. I had seen that thing. In the above, it has been written slideshow.
Slideshow.
Yes, sir. Just a little bit above slideshow.
Stop, mute, participant, question, news, pause, remote apps, mode. Your screen sharing. So slideshow is here, lower side.
Okay. Sir, they are also in the above also. I can see your screen. They are also in the animation. After animation, there is having slideshow review view.
Okay. Actually, on now it is visible. New slide.
No, sir,
No,
it's
sir,
not
still
visible,
no.
sir. Sir, please stop sharing, sir. Now click on share screen button and click on screen button. Don't click on your PPT, sir.
Screen
Sir,
button,
don't share your PPT. Only share your screen.
share screen,
Yes, sir.
then next,
Yes, sir. Please share your screen.
say
Just
PowerPoint.
click on screen button and then click on share button.
Oh, screen and share.
Yes, sir.
Yes, sir, now it is visible. Good.
Okay,
Now it's
thank you.
fine, sir.
Thank you. Actually, we use WebEx generally from my office. So this is new for me. So I have told that this is a single invention in which there are 5 types of IPs. First, the LED display, which will comes under the patent, and the Apple symbol will comes under the trademark, and the body of the design, body of the laptop will comes under the design, and the user manual, which is provided in the laptop for the how you can use this, will comes under the copyright protection, and the layout of the IC will comes under the SICLD design. So, so before filing a IP, means the patent, design, or trademark or copyright, you should know which type of IP can be protected for our invention, for our research. So these are the pros of patenting system. After getting a patent, you can get incentive to do innovation and investment in R&D activities in any field. How you can disseminate your technology and how you can commercialize of your invention, I will discuss in later in detail. And after getting patent, you can promote your technology, or you can and you will have attract more foreign direct investment. And these are the cons of patent system: higher price of patented products, less competitive market, abusive activities of patent holders. So these are the benefits for the common person. You will get pride and you will get academic value after getting a patent. And for a businessman, they can earn money after commercialization. They will have a brand value and they can earn and invest after getting IPs. So what is patent? A patent is a grant by a nation or group of nations. It means a patent can be granted by a nation like India, Bangladesh, but patent can also be granted by a group of nations like European Patent Office, USPTO, grant the patent to an inventor or his assignee. Inventor means the person who invent the IP, but the assignee means, for example, you are working in IMIT University as assistant professor, then you are inventor, but Amity University will be assignee for your invention, for your patent. So the patent will be granted with the name of Amity University, and your name will be written as an inventor in the patent certificates. So a grant by a nation or group of nations to an inventor or his assignee, conferring upon the right to exclude other from making, using, selling, offering for sale, and importing his invention for a limited period of time. Patent is granted for 20 years from the date of filing of patent, not from the date of grant of patent. So our office already lapse your 3-4 years of patent in lieu of the disclosure of the invention in a patent specification. These are the facts of patent. Patent right is a qualified right. It does not automatically give the owner the right to exploit his invention, but certainly gives the right to restrict others from exploiting his invention. Patent right is a territorial in nature. That means a patent granted by India is valid in India only. Similarly, a patent granted in USA is valid in USA only. So there is nothing called world patent or international patent. Patent is, if you are wishing to file a patent in China, then you have to file a different separate application for a China. So PCT application, generally people say that I have an international application or a world patent. Actually, they said about the PCT application for the WIPO publication. And WIPO is not a patent granting authority, because patent is, I have already told, patent is can be granted only by a nation, and WIPO or PCT is not a nation. So this is the PCT. WIPO is just a receiving office or a examination office where you can examine, examine your patent application for the novelty or the inventive step and for the other criteria. these are the types of patent application. First is the ordinary application. Ordinary application can be filed by any Indian applicant and it is filed in the Indian Patent Office. There are 4 patent offices in India: Delhi, Mumbai, Kolkata, and Chennai. According to jurisdiction, you have to file your patent application. For the Amity University, Jharkhand, if the Amity University, Jharkhand is filing a patent independently, means without any permission or without any affiliation from the Amity University, Noida, then you have to file your patent application to the Kolkata office. But in my knowledge, according to my knowledge, Amity University combinedly file a patent from the Amity Noida. So your application will first go to the Noida, and then Amity Noida will file patent to our office, Delhi office. So ordinary application is filed according to jurisdiction and can be filed with provisional or completed specification. Provisional application means if your research is not completed yet, then you can file your application as a provisional application. By filing the provisional application, your application will be protected from the date of filing a provisional application, and you will get 12 months. You will get 12 months for completing the research. And then after completion of research, you may file your complete specification within 12 months after provisional filing. But if no complete specification is being filed within 12 months, the application will be abandoned. So provisional application is just filed for getting protection from the date of filing. Convention application. Convention application, if a person has made basic application in convention country, you can file a convention application in India within 12 months. For example, you have filed your patent application in India, and then you are wishing to file in China or in Bangladesh or in Europe, then you will have only 12 months to file a patent application in different countries. And this type of application is called convention application. So 12 months is very less for filing a patent in different countries, because you have to contact with the attorneys of Europe, you have to contact with the attorney of the Bangladesh. So 12 months is very less. That's why the PCT international application has been introduced, and through this channel you will have 31 months to file a patent in different country. First, and for this process, first you have to file your application in the PCT, and India is also a receiving office of PCT. So you no need to send the file to the WIPO office. India Delhi Patent Office is a designated receiving office. You can file your PCT application there, and the fee is very less. Only 1,500 rupees is for the examination, filing, publication, everything. So you have to file application in Delhi Patent Office, and there the patent application will be examined by the Indian examiners, and then you will get an international search report, ISR. And in the ISR, you will get the search report like whether your invention is novel or not, whether your invention has an inventive step or not, whether there is clarity or the definitiveness objection. So once your patent application will be examined under the ISA or the PCT, then you can file your patent application to different countries. So it will give you 31 months, and 31 months is much for the filing patent application in different countries. So when you file your application in PCT and then you move to a different country, this application is called PCT national phase application, because you are entering in the country, and then after filing your PCT national phase application in India, the application will be examined as an ordinary examination, ordinary application. And if you have a filed, for example, a Japanese has filed a PCT application in Japan receiving office of PCT, then they will file a patent in the Japanese language. But if he is wishing to file in India, then first they have to translate in the English and then file to the India. Divisional application. Divisional application is a type of application in which if the patent office has objected your invention as a multiple invention. That means in the single invention there are more than one invention. For example, a person has invented a table and chair for the kids, in which the table and chair are attached with each other, and they claimed as a product. Our office can raise an objection that since the making process of table and the making process of chair are different, so there are two inventive concepts in your invention. So it is better to file a two different application, separate application, one for the chair and one for the table. So office will suggest you to divide your application and file a separate application. So this is called a divisional application. But if a person has claimed a process and product in a single invention, for example, a herbal composition for the treatment of cancer, this is the first claim. Second claim is a process of preparation of herbal composition as claimed in claim 1. That means they are claiming the process and product in the single invention. Then it is not a two invention. It is a single, because there is a single inventive concept. First, you are claiming the product after making that product. So this will not a two application. Patent of addition. After filing a patent, if you came to know that there is a need of modification of your invention, or this modification should be minor modification. You cannot add a new matter, or you cannot add the new subject matter, only the modification, minor modification, or any improvement. For example, you have filed a patent application for a DNA isolation method, and you are claiming that there are 4 steps is required. There are 4 steps required for the DNA isolation, and after further research, you think that one step I can remove one step. Then you can file a patent of addition and claiming that there is a need of only 3 steps in DNA isolation. Then it is called as patent of addition. So in patent of addition, no new subject matter can be added. Only the minor modification or improvement in the parent application is allowed. So how you can draft your invention? Drafting is very important, because how you draft your invention may leads to the granting chance of patent. For example, there was a patent application filed by a student, and they have claimed that the first claim is a device, a apparatus which reduces the meter reading, electric meter reading. That means he is claiming a machine which can reduces the meter reading, means lowering the electricity bill. This is a type of theft. But if he has drafted in such a way that a device or an instrument which can reduces the power consumption of electric appliances, it is in good sense. But same invention has been filed by different way, then first will comes under the type of theft. Section 3B will reject that invention. But in the second type of drafting, it seems like it is for a human welfare. So this is the structure of a patent specification. It is very simple. Like a research paper, you can write a patent application also. It contains the abstract in the same like a research paper. Background of invention, in which you have to describe what are the needs of invention. It means what are the previous literature related to your invention and how it is different from the previous literature. And the second is the summary of invention, in which you have to describe how the invention works and what are the examples, like experiment 1, experiment 2, experiment 3, and the data. Data means efficacy data or efficiency. For in case of machine or device or apparatus, you have to provide the efficiency data. Means how your machine is efficient from the existing machine. And in the case of medicine or the formulation or the drug, you have to provide the efficacy data. Efficacy data may be like a solubility or the stability or the half-life, etc. And the third most important part is the claims. Claims are just a sentence, single line sentence, in which you have to write the extract of your invention. For example, you have made a chair, and the chair is suitable for the handicapped people, and this chair is also suitable to for the walking or for the climbing on the tree, etc. So after describing all the invention, you have to write a claims, and the claim will be like a chair, or you can write as a 4-footed seating arrangement. Means you have to describe your invention. If you are claiming a pen, then try to write as a handwriting instrument. not a pen. And the writing instrument will cover all pencil, pen, chalk, bold marker, permanent marker, all will covers under that. And if you are claiming a four-footed sitting arrangement, that means you are claiming a stool, a chair, a table, or bench, anything, everything. So first try to broaden your invention. And after drafting the claims, you have to draw, if your invention is related to the engineering or any biological diagram, then it will come under the drawing. And if the invention is related to the DNA, RNA, or protein or polypeptide sequence, then you have to submit the sequence listing in the CD or the DVD. And if the invention is related to the biological material, that means you are claiming any biological material like a microorganism, bacteria, or the virus, or the fungi, and the strain, and you are claiming that a strain is novel, or the hybrid, or transgenic, then you have to submit in deposit it in the IMTech Chandigarh or the NCCS Pune or NABIM MAU. There are three designated deposition center under the Budapest Street. So after filing a patent, how our office process your application, we can see in this chapter. So these are the forms required for filing of patent. Form 1 is just a application for grant of patent, in which you have to write the title, name of invention, title of invention, name of inventor, address of inventor, email IDs, phone numbers, etc. And some declaration like whether you have used a biological material taken from India or not. And form 2 is just a complete specification, in which you have to write the description, claims, abstract, drawing, etc. Form 3 is the statement and undertaking about the foreign filing, whether you have filed your application in foreign country or not. And form 5 is declaration as to inventorship. That means the university or the institute or the companies will give a declaration as your inventorship. Form 18 is for the request for examination. Many times Indian inventor filed a patent in their patent office, and they just wait for the grant of patent. But after filing a patent, it is necessary to file a Form 18 for the examination of your patent application. Without filing the Form 18, your application will not be examined. And after 48 months of filing a patent application, your application will got abandoned. So it is better to file Form 18 at the time of filing. And Form 18A is a special Form 18A is a special form for the examination purpose, and it is only for the expedited examination. That means if you are thinking about the expedite process of your patent application, then you have to give the additional fees for the expedite examination. And who are the eligible for the expedite examination? I will show you the later slide. Form 9 is required for the early publication. When you file your patent application in Indian Patent Office, then after 18 months, your application, your abstract is published in the Indian Patent Journal, and it takes 18 months. 18 months is the minimum time period decided by the WIPO, and there is a process in which you can get early publication by submitting the Form 9 with extra fees. And after filing Form 9, your application will be published within 7 to 15 days after filing a patent. So these are the basic timelines. Means after filing the provisional, you have to file the complete specification within 12 months. You have to submit your Form 18, that means request for examination form, within 48 months from date of filing. And after filing a patent application, you have to submit the Form 18. And after Form 18, we as examiner examine your application under the novelty criteria, inventive step, and other section according to the Indian Patent Act, and we issue a first examination report. And you have to reply the first examination report within 6 months from date of issue of first examination report. And there is also an option for the inventor to withdraw your patent application. Because, for example, a electronic and communication scientist has filed a patent for the 2G in 2002, and after 4 or 5 years the patent application has not granted this application, and because as patent office has a very big pendency. So after 4-5 years, there is no any meaning of 2G patent. So the inventor can withdraw their patent application. In the same way, any drug or any vaccine or any antibiotics uh, may the filed patent can be withdrawn by the inventor also. So these are the fees for the filing patent. Application for grant of patent means the application for filing a patent is only 1600 for the natural person and for the universities also. And the publication fees is 2500 only. The request for examination is 4000 only. So fees is very nominal. You can file your patent application directly to the patent office by rushing to the counter or by sending it by the speed post through the demand draft, or you can file your patent application by online mode also. But filing through online mode, you have to have a digital signature, and you can get it from the TCS and other e-mudra companies. So who can apply for expedited examination? Any small entity or a natural person, and the natural person must be female. Or if 4-5 people are filing a patent, means there are 4 applicants in a patent application, then one should be female applicant for expedited examination. Otherwise, it will not be examined under the expedited case. Any department of government or any educational institute, whether it is government or private, doesn't matter, can file a patent for the expedited examination, or any government company or a startups, etc. So these are the formal parts of the patent application. Now come to the technical part of the patent. These are the criteria for the patentability, novelty under section 21J, inventive step under section 21JA, and the industrial applicability. So after this is a life cycle of a patent application. Filing of patent application with complete specification, it will publish under section 11A within 18 months, and after publication there is a window open for the opposition, and this opposition can be filed by the any person. It doesn't matter whether he is working in the same field or he is a scientist, doesn't matter, any person. Even the patent agent, even the patent attorney can file opposition against your application under the novelty, inventive, or in any. There are 25 criteria provided in the Patent Act. There are 25 grounds on which the opponent can file opposition against your patent application. We may consider his opposition or not, but once they filed a pre-grant opposition, then we provide a hearing opportunity to both parties, means the inventor and the opponent also. And after hearing, if we think that the opposition ground is valid, then we consider their opposition, but we do not refuse their patent application. We just consider their opposition ground and incorporate all these things in the first examination report, and we give opportunity to the applicant for reply. So patentable invention, what is patented invention? Only invention, not discovery, not idea. Discovery and ideas are not patented. Section 2(1) says that an invention means a new product or a process. I have already told. Only two things can be patented. One is a product or a process. No any study, no any findings are patentable subject matter. Generally, for a paper purpose, for a research paper purpose, we do a work on like a study on this finding, like a new roles, but only patented subject matter is product and process. So an invention means a new product or process involving an inventive step and capable of industrial application. And section 2(1)J says that inventive step means a feature of invention that involves technical advancement as compared to the existing knowledge. Means the invention must have a technical advancement as compared to the existing literature, or having economic significance, or both. And that makes the invention not obvious to a person skilled in the art. That means, for example, an umbrella. A mechanic has invented an umbrella. An umbrella has a LED bulb. on the tip of the umbrella, and he claimed that umbrella can be used in the rainy days, rainy nights, and it will protect you from the any collision from the head-on collision from the vehicles, or or you may protect it from the insects and the snakes. But whether the arranging the light LED bulbs on umbrella is required a mental exercise or not. For example, an emergency light having light and fan, but you as a mechanic, you are electric mechanic, then you add more instrument like a charging point of mobile, or you can add like a watch, you can add a FM kit in the said emergency light. So this is a very common task, very common routine, obvious work for a skilled person. Prior art. When we examine your patent application, then we search a prior art for your application, means any publication, whether it is published in the research paper or in the newspaper or on the YouTube or the videos or any exhibition or any patented literature, all are called prior art. And we compare your invention by prior art. And the prior art may be your own invention also. If you have published your paper in any reputed research paper or any journal, then your research paper will also be as a prior art for your invention. So it is my advice that first you have to file your patent application, then go for the paper publication. So this is the case study of novelty. Invention is relates to a composition for enhancing corneal healing. Said composition comprises vitamin A and a sterile buffer. So applicant is claiming a corneal healing solution in which the vitamin A and a sterile buffer are there. And prior art says that after searching the prior art says that use of eye drops to rewet contact lenses, wherein the eye drops contains vitamin A and a sterile buffer. So analysis says that the claims lack novelty as being anticipated by the said prior art because same feature, contact reweighting contact lenses by vitamin A and sterile buffer is already disclosed in the prior art. So the claim subject matter lacks novelty. This is the second example of novelty, and it is related to the agriculture science. Claims are the yeast can be preserved in the form of jaggery bar. This jaggery bar can be stored at 8 degrees Celsius, where the yeast survives up to 3 months. Prior art D1 says that yeast in the form of jaggery bar can be stored at 8 degrees Celsius and for a period of 3 months, and that also claiming the same purpose as a biocontrol agent for seed or soil treatment. So D1 anticipate the subject matter of claims 1 to 4. This is an inventive step, technical advancement, having economic significance, or both. This is the case study of inventive step. The invention is related to the pharma and a composition comprising inulin and a sulfonyl urea. That means, and this composition
Dhananjay sir, I think some network issues is there from sir end.
Yeah. You are muted. Please unmute yourself, sir, first.
sorry, was disconnected. So this is the example of pharma in which we can see the whether the invention has inventive step or not. So the applicant has claimed a composition comprising inulin and sulfonyl urea. So and they are claiming that it is useful against the type 2 diabetes mellitus. So prior art says that sulfonyl urea are known to use to lowering the blood glucose level in type 2 diabetes mellitus. However, the side effect of adverse reaction associated with the sulfonyl urea is the hypoglycemia and weight gain. So the applicant has made a new composition and he has added the inulin in the sulfonyl urea and provide alternative treatment with efficacious blood glucose level control and improved adverse reaction profile. So here the efficacy is in the sense of the adverse effect or the side effects of sulfonyl urea. That means the applicant has worked on the adverse effect of already claimed product sulfonylurea. So inventive step is there because aniline is able to prevent or ameliorate hypoglycemia and associated with the sulfonylurea. This is the case study of agriculture science invention. A bioformulation, and this is the application of IRI Delhi. A bioformulation of PUSA 5-ST for the seed treatment, comprising potential isolate of trichoderma along with peat powder, sabudana powder, and carboxymethyl cellulose. So here the applicant has claimed a strain, and the strain is novel, Trichoderma harrisonum, and the number is MTCC number 537. So since the strain is novel, and an inventive step lies in that the seed formulation has a shelf life of 25 months. So 25 months is a very huge shelf life. So inventive step lies in the shelf life, and since the strain is novel, so analysis says that the claim subject matter involves inventive step. After three criteria like a novelty, inventive, and industrial application, these are the sections, section 3 and section 4, which says that these are the if the invention related to section 3 and 4, then they are the non-patentable invention. Whether it doesn't matter whether it is a novel or inventive, but if this invention falls under section 3 and section 4, then the patent will be not granted. So section 3b. Section 3b says that any invention contrary to morality or which causes serious prejudice to human, animal, or plant health are non-patentable inventions. I have already told a machine or a device which reduces the meter reading, like it is like a theft. So any device, apparatus, or machine or method for committing theft, or any machine for counterfeiting of currency notes, or any device for a gambling, or any process for adulteration of food or the cloning of humans, device of housebreaking, these all are non-patentable invention under section 3b. Section 3c says that any naturally occurring compound, whether it is a living or non-living, doesn't matter, are non-patentable under section 3c. For example, this is the case of Tropilites foods, and they claimed a sulfur-containing anticandidal molecule isolated from Emericella species. So the anticandidal molecule is already existing in the Emericella species bacteria. So applicant has claimed a naturally occurring molecule. So this is non-patentable under section 3c. This is not a invention, this is a discovery. Section 3d. Section 3d is important for the pharma and the chemistry people. So any discovery of new form or new use or a mere use of known substance are non-patentable invention. For example, fluorescence fluorization assay for detection of brucellosis in buffalo. So here applicant has used a technique, already known technique, fluorescence fluorization assay for the detection of brucellosis in buffaloes, comprising the step of growing B. abortus S99. So he is using the B. abortus S99. And B. abortus S99 is the causing agent of brucellosis. And the Nielsen et al., which is the prior art, says that already disclosed a fluorescence fluorization assay for detection of brucellosis in buffaloes with B. abortus S119. That means the same process applicant has used with different strain. So the process is same. So they are using the same process, near use of known process. So claims has used the new use of a known process. So it is a non-patentable invention. Second is a fertilizer composition comprising a fertilizer core comprising from about 0.8 to 0.8 gram of nitrogen and a polymer layer. So this is a new form of known substance. For example, you have changed the tablet form to syrup form or syrup form to a spray form of a same drug. Then you are just changing a form of known molecules. So this is a non-patentable invention under section 3. Section 3. Any mere admixture resulting only in the aggregation of the properties or a method of making such mere admixture. That means, like they have claimed the mouth freshener composition comprising curcumum longa, piper longum, or the mentha. And for example, other example is like a composition of paracetamol and ibuprofen to control pain and inflammation. So this is just a composition of two different drugs. So analysis says that the compound used in the alleged invention are known for their activity, because already paracetamol is known as an antipyretic and ibuprofen is the analgesic. So the applicant is silent on the combinative effect. If the combined effect is much more better than the individual effect, then it is patentable invention. So it is not necessary that any composition are non-patentable invention. But if applicant prove that the combined effect is more than the individual effect, then the patent may be granted. Section 3F. Section 3F is for the instrument or apparatus, claims for instrument or apparatus, which is just a mere rearrangement. Already told that a emergency light already have a fan, but you have added a light, you have added a FM radio, you have added a mobile charging point. So this is just a rearrangement. So these are, for example, a machine for cultivation in agriculture field comprising a frame and a soil cultivating tools, which are driven by electric motors. A frame, a device for planting tree, device for cutting tree. Means a single device. There are two types of device. First is the planting tree, and second is the cutting tree. So it is just a mere rearrangement. No any mental exercise is needed for this experiment, this invention, and it is obvious for a skilled person. Section 3H says that any method of agriculture and horticulture, like a plant breeding, crossing, hybridization, insect pest management, spraying, weeding, plowing, etc., are not patentable invention. So for example, a method of growing leguminous plant as intercropping is a method of agriculture. A method of plant breeding method is a method of agriculture. So these are the non-patentable invention. Section 3I. Section 3I says that any method of treatment or any diagnostic method are non-patentable invention under section 3I. For example, a method of monitoring drug response in a patient suffering from cancer. So here the applicant has claimed the subject matter which is directed to method of diagnosis of human beings or animals, which are non-patentable under section 3I of the Act. Section 3J says that any plant, an animal or its part, seeds, leaf, plant tissue, stems, or essential biological process like photosynthesis, respiration, somatic embryogenesis, callus formation, germination, these all are essential biological process, are non-patentable invention. Example, a plant of an agronomically elite soybean variety. So here applicant is claiming a soybean variety. That means the plant, whole plant. Second is a process for mass production of mycorrhizal inoculum. Means applicant is claiming a mass production. That is a natural process, essential biological process. A method of preparing marker-free seeds means essential biological process. Section 3P says that any traditional knowledge related invention like a novel herbal composition effective against rheumatoid arthritis comprising gingiber officinale, suranjan, piper nigrum, and Withenia somnifera against the rheumatoid arthritis. This is the application of Central Council for Research in Unani Medicine. We do search in the TKDL library. TKDL is a traditional knowledge digital library which has been made by the CSIR and Patent Office combinedly. And this is a database in which we can see it is a public database. You can also use this database and you can do search in the TKDL library, in which you will see the literature, Sanskrit literature or the Unani literature of all already known medicinal plant uses. So this is the use of Suranjan syringe in the 17th century. They have already used, and for the piper nigrum and for the Withenia somnifera. So these databases are continuously updating because all literature known are in the Sanskrit and Unani. So they are translating this. And one important thing is compulsory license. Compulsory license, section 84 says that this was a hot topic during the COVID vaccine compulsory license. Section 84 says that at any time after the expiration of 3 years from the date of grant of patent, any person interested person means here the word is written interested, not any person. Only interested person. That means a person who is working in the same field, a person who has any monetary loss, and person who has the same background can file for the compulsory license only after the expiration of 3 years from the date of grant, on the following grounds, like that the reasonable requirement of the public with respect to the patented invention has not been satisfied. Second ground is that the patented invention is not available to the public at the reasonable affordable price. And C, that the patented invention is not worked in the territory of India. These are the 3 grounds on which an interested person can file for a compulsory license. This is the case study of a compulsory license. In a year 2012, Patent Office issued a compulsory license to the NATCO, and the drug was Nexavar. And Nexavar is an anti-cancer drug used against the liver and kidney cancer. And the original patent has been granted to the Bayer Corporation. And this medicine is used for the liver and kidney cancer, and 1 month's worth of doses cost around 2.8 lakhs. NATCO Pharma has filed for the compulsory license and offered to sell it around for only 9,000 rupees for 1 month. So government took this decision for the general public benefit, and the compulsory license has been granted to the NATCO for the next year with a 6% royalty to the Bayer. And the last is the section 4. Section 4 is says that any invention related to atomic energy, like and you are using, if you are using a radioactive material like uranium, plutonium, thorium, beryllium, etc., then your filed application will first transfer to the Department of Atomic Energy, Government of India, and then after examination or the screening from the DAE, your application, if they think that your application is okay and for the human welfare, then they transfer this file to our patent office. Then our patent office examine and prosecute in the same manner as ordinary application. So after getting a patent, there is a very big problem of commercialization and technology transfer of intellectual property. Means how you can transfer or how you can commercialize your patent to earn the money, because already Dr. Dhananjay already told that patent is a tangible property. So after getting a patent, you just have to earn a money from your patent. So there are 2 platforms made by the Government of India for transferring of technology. First is the NRDC. NRDC comes under the Ministry of Science and Technology, and its vision is to be a leading technology transfer organization in India, and its mission is to promote, develop, nurture, and commercialize, innovate, reliable, and competitive technology from R&D. So after getting patent, you have to do nothing. Just write your or just upload your invention on the NRDC website, and the person interested can search and can see your invention on the NRDC platform, and they can show interest in your invention, and you will get a message or mail from that interested person. And if your invention is related to any agriculture or the dairy or the agriculture allied science, then there is a separate platform, Agri Innovate India. It comes under the Ministry of Agriculture and Farmer Welfare. So the invention other than the agriculture can be uploaded to the NRDC, and the invention related to the agriculture can be uploaded to the Agri Innovate India. Thank you.
Thank you so much, Ashish Pravat sir. It was really nice hearing all the aspects of patents, life cycle of patents, various types of patent, what are the legal aspects of patent. So in a nutshell, you have described everything that one should know before filing a patent. But Before I start the Q&A section, just a small query from my side, and I would like to request our panelists as well as the members or the attendees who are watching this workshop, kindly post your queries in your Q&A section. Okay, coming to my query, I would like to ask more for a design patent. Being a mechanical engineer, I would like to know what are the various aspects, how someone can fill a design patent.
Okay. So first of all, you should know that design is not patented. Design is registered. Patent is only granted for the invention and for the design. Means you have designed a machine, any three-dimensional machine. You have designed a three-dimensional machine. You have to go design office, and the only design office is in India is in Kolkata. So, for example, this is your machine, and you are wishing for the design registration. Then first you have to take 7 photographs of your design application. First from the left, right, top, bottom, left, right, top, bottom, and for one is a prospective view, means just put in this position, and the 7 photographs is required. And take 7 photographs, take printout of these photos, and fill a form 1. Form 1 is available in the patent office website, and the required fee is 4,000. Make a DD of 4,000 and submit to the design office. It's a very simple process. No need to write anything. No need to write any explanation of machine, how your machine works or not. Any working mechanism principle is not required. Only photographs is required. Clean photographs.
Okay. Okay. Thank you so much, sir, for answering my query. Now, I would request our honorable Vice Chancellor, sir, who is attending this session, to share a few words with us. Honorable Vice Chancellor, sir. I think is not able to hear us. Chaitanya, please, can you call sir for telephonic call to sir might be. Okay, so adding on this, I would like to have the question and answers from our panelists.
Yeah, I have just a quick query that, for example, any patent has been granted in, for example, any other country like Japan. So, can that intellectual property patented in Japan be used? Can be used here in India by someone? Means is there any legal violation on that, or because that is not patented in India, so anyone can use that here?
Yeah. For the protection purpose, if you are wishing to protect your invention in different countries, you have to file a separate patent application in different countries. So only after granting the patent in one country, you will get a protection in that country. So a patent has been granted in Japan by a Japanese people or any person, and since it is not filed in India and patent has not been granted by India for that patent, then you are free to use his invention in India. No problem.
It means vice versa. If we want to get protection on our intellectual property throughout the world, we have to file each and every country.
Yeah,
like that.
Yeah.
Okay. Thank you.
Thank you so much, sir. Any other queries from our panelists or the attendees? So now, thank you once again, Prabhas sir. Now I request Dr. Amit Kumar Datta sir for the vote of thanks.
Thank you, Rahul sir. Am I audible?
Yes, sir.
Okay. At the onset of the blessings of our Honorable Founder President, Dr. Ashok K. Chauhan sir, our Chancellor, Dr. Atul K. Chauhan sir, we are very much thankful to our ever supporting Honorable Vice Chancellor sir, respected Director sir, and respected Registrar sir, for allowing us to conduct this one-day workshop on intellectual property right. We would also like to thank today's expert guest, Mr. Ashish Prabhatji. Sir very precisely explained the details ins and outs of the patent filing system. Once again, thank you, sir, on behalf of IISc AUJ and AIB for accepting our invitation. We would also gratefully acknowledge to all the program coordinators, sir, and madams, especially Dr. Sobna Chaudhary, madam, for her kind help and support. We owe our deep gratitude to Dr. Jaita Chattopadhyay, ma'am, UC R&D cell, for her cooperation to bring this concept of IPR webinar as well as workshop at AUJ. We also thanks to the admin and media cell for their support. On behalf of AIB and IISc AUJ, we also thanks to IT host team Noida.
सर डायरेक्टर सर के पास अप्रूवल के लिए क्या हुआ? BC की सर लॉकडाउन लगा था
Noida
जो सर अभी
and
कुछ दिन
Rachi,
पहले सर को असाइन किया था.
especially Mr. Maksudji for providing smooth IT platform for conducting this workshop. We are also thankful to the participant who joined with us. I am also thankful to Dr. Rahul sir, convener IISc AUJ, IISc cell, and moderator of this workshop, and Dr. Dhananjay Kumar Pandey sir, President IISc AUJ, and joint convener of this workshop for their all-time help, support, and cooperation. I am also thankful to Institution and Innovation Cell IISc AUJ, Intellectual Property Office New Delhi, Ministry of Commerce and Industry, Government of India, and National Intellectual Property Awareness Mission, NIPAM, for allowing us for their support and permission to conduct this workshop. So thank you once again, and over to Rahul sir. I think VC sir is now free, so I request at the end to say few words. I know sir you are busy, so I request VC sir to say few words to
Thank you very much. I could only hear some part of it, but I was looking at the PPT which was being shown, and I was happy to see that a lot of detailed presentation was made by the representative from NIPAM. And can I request him to share the PPT if possible? I would say that with this background, our discussion must begin at AUJ. I am busy so that you can have patents. Otherwise I'll keep you busy so that you can never have your patents done then. So when the teachers, the researchers have the freedom to work, and there is a guidance from experts also, this is the best time to get the patent, best time to get the copyright, and really contribute with full force. So that is how I expect the faculty members to use the time, and your targets are already before you. So I am on my target. Please be totally on your target with full force. And once again, I would like to thank Mr. Ashish Prabhatji for giving this session. And sorry that I was not part of it fully, because today has been possibly a good day of engagement. And I look forward to many such days so that I'm more busy. I don't have to add anything here. Rather than initiating the discussion among ourselves, and plus having the expert guidelines once again, wherever you feel there is a need for it. Our innovation cell and the research cell must remain in touch with experts in this, and whenever any faculty needs any such help, we also slowly equip ourselves and become experts in these areas, or seek their help as and when required. So my best wishes. Let the university, I would say, come. They are already dedicated. That I know, and I'm sure. But let that also be reflected on paper, in the government records, in the AIS, SHE records, UGC records, that Amity University, Jharkhand is a different university. Can we build that? And if you can see that in your lifetime while you are active, well, that's the opportunity you have in your hands. My best wishes once again. Thank you very much. All the best.
Thank you so much, sir, for your word of wisdom. And I do believe that research and publication and patent are not a destination. It is just a part of journey that we have to continue. With this word and from your permission, we would like to end this session.
Yeah, please.
Thank you so much, sir.